people, what's up? Here I am with RTP people. So this is the RTP we are doing for Jan 2025 onwards. So there are some good questions, easy questions given in your institute. So I thought, why don't we just solve it? Yep. So let's take it up. And so just sit back and relax. If you guys know the provision, I'll be telling you the answer, but I want you to take a book, write down the provision for whatever is the answers I'm discussing. I don't want you to write the entire answer and all. But I just want you to at least write it down in a paper. This is the provision. Provision is what the subject words. I don't want you to write the entire paragraph. At least what is the topic they're asking from. That at least you should be able to write. Write it down. Write it down. Go. Write it down. Get a book and pen. Go. Got it down. Yes, Sam. Okay. Let's start. Case scenario. I will always go from top to bottom. Easiest for me. Whatever works for you, you also do it the same way. Given that ABC made first financial year ended on 31st March 2024 and it was incorporated on 1st January 2023. So it was incorporated on 1st January 2023. What is the latest date by which ABC Limited must hold its first AGM? So technically for me here, I know, but I'm not telling you to answer this way. But easiest way, so see, it's simple. I don't know which company, nothing. But what are they saying? 1st January 2023 is what you incorporate. Any company which is incorporated after 31st December, then your financial year will end in the subsequent year. So my financial year will end on 31st March 2024. The last day for me to conduct the AGM will be the first AGM, 9 months. That will be 31st December 2024. So B will be my answer. I don't even know what is there above. But macha, not always. Yeah? It is always better to go bottom to top. If at all this is not sufficient, we'll go back and see. Suppose ABC Limited holds its first AGM on 15th December 2024. See? By when must it hold its subsequent AGM? They are trying to question you. What is the maximum gap that can be there between two AGMs? It cannot be more than 15 months. But remember, that doesn't mean that if I've held it on this day, I can take 15 months from 15 December. The maximum date has to be within 6 months of completion of financial year. You have to follow everything. So subsequent financial year, subsequent AGM has to be conducted within 6 months from the closure of financial year. So you need to take it this 15 months from the date of the AGM or 6 months from the closure of financial year. You can take it this way, whichever is earlier. Macha, nowhere it is written. You guys don't write it up as a theory. It is only for our understanding. So whichever is earlier, it will always be 30th September 2025. Correct, huh? Yes, sir. Okay. See, still I have not seen this entire prefix and index. But again, I am telling you, whatever is the method I am doing is wrong. But if there is a question that comes, something like that comes, we will go back. But I am just expecting you to see this and go back. If we will see if there is any question, we will go back and read again. Under the Companies Act 2013, does ABC Limited need to prepare consolidated financial statements to present it at the AGM? See, we don't know this. We need a index. We'll see. What must ABC Limited ensure to pass a special resolution approving the adoption of a new e-commerce business model at the AGM? What must ABC Limited ensure to pass a special resolution? What would they ensure? The resolution must have more than 50%. Allah, this becomes the ordinary resolution. The resolution must be stated as a special in the notice. And votes in favor must be 3 times the votes against. Correct? Huh? The resolution can be passed if votes in favor exceeds votes against. Allah. The resolution must have unanimous. Allah. So B is my answer. Huh? That's what a special resolution. Huh? Done. B is my answer. Under which conditions would ABC Limited be exempt from preparing consolidated financial statements? Under which circumstances? When is the company exempt from preparing consolidated financial statements? When? If ABC Limited is a wholly owned subsidiary, all members agree in writing to be exempt and proof of. Correct? That's all. That's all is the answer. If you guys were part of my class, then Macham, we have written it down everything. I hope all these points we have it in our chat book. We have written in the in our class. Correct? So this is the only question. Under the Companies Act, does ABC Limited need to prepare consolidated financial statements? Yes, because it has one wholly owned subsidiary and an associate. No, because it qualifies for exemption as a wholly owned subsidiary. Yes, only if XYZ Limited and MNO Limited are listed companies. No, if shareholders provide written consent exempting it from CFS preparation. So, yes, sir. Yes, because it has one wholly owned subsidiary and associate company. Correct? Yes, sir. That's the answer. Okay, sir. Done. Okay. See, I have not done it. You guys are expected to go back and see what the question is. Somehow for me, most of the cases it works like this. In this scenario, which of the following is correct based on LLP? This we don't know. Okay, we'll see. XYZ LLP is a consulting firm where 4 partners A, B, C and D are responsible for various functions. Partner B, without consulting the other partners, enters into a contract with a third party, Mr. P, for a high value procurement deal on behalf of XYZ LLP. It is later found that partner B did not have authority to engage in such deals. So basically there was a limit, scope was limited by agreement, and XYZ LLP has no history of involvement in procurement. They have never purchased, so it's not their ordinary course of business. Mr. P, who is an experienced business person, was aware that partner B was not authorized to enter into procurement deals for XYZ. So what is that, people? Simple people. When will the scope be limited? Now a partner, in this case who is it? P, without the authority, meaning his scope was limited, but still he has gone and entered into a contract with P. They're telling you, is the LLP liable for it? It will be liable, people, when P does not know that this particular scope was there on B. If they can prove, and I'm an innocent person, I acted in good faith, then yes. In this case, they have clearly given people, he was aware that partner B was not authorized to enter into procurement. Even after that, then, why did you do it? Then why will you come to court and cry? XYZ is bound, illa, not bound, yes sir. Because who will suffer the loss? It is P's responsibility. You will suffer the loss. Yes sir. P knew of this. That's very important. Simple. Okay. Next one, people, again we have written this in your notes. ABC LLP was incorporated with 2 partners, Mr. Raj and Ms. Rani. Due to certain differences, Ms. Rani resigned from LLP on 1st January 2024, leaving Mr. Raj as a sole partner. Mr. Raj continued running the business without admitting a new partner and was aware that he was the only remaining partner. Macha, whenever the number of partners reduce the minimum requirement, and the partner who is aware, cognizant of the fact, continues beyond 6 months, shall be unlimitedly and personally liable for the contracts entered post that period. Correct? He was the only remaining partner and aware. This is very important. They can play with you here. If he was not aware, you cannot catch him. You cannot hold him liable here. Same thing applies to your Companies Act also, Section 3A, if you guys remember. So given the provision, Mr. Liability, easy liable, will not be, will be. Where is will be? Will be iruka, yenga iruko. Will be personally liable. Both obviously only the continuing partner. Dissolved and all. See, people, this is also correct. LLP will be automatically dissolved. This is also correct. Provided and no personal liability will arise. This is wrong. Personal liability will be there. Post 6 months, if you are still continuing, that is one of the grounds for dissolution. Remember. Okay. Mr. Amit, the chartered accountant, is appointed as the auditor of Grey Limited. Ms. Anita, Mr. Amit's wife, Recently acquired equity shares in Grey Limited with a face value of 1 lakh. Which of the following statements is correct? Simple people, a relative can hold security up to 1 lakh, but not the auditor. In this case, its wife, up to 1 lakh possible, allowed. So it is allowed. Whichever option says it is allowed. Amit must vacate, illa, not can continue as auditor only if Miss Anita divests her share. No, no, no. They are telling you here he can continue provided she should sell. No such requirement. Can continue. Held do not exceed the limit specified. What is the limit? Is 1 lakh. Correct? Done. Next one. XYZ Limited is a company with 51% of its equity share held by state government and 49% by private investors. So it's a government company. The board seeks to appoint an auditor for the upcoming financial year. As per Companies Act, which of the following is correct? Obviously, it's a government company. CAG shall appoint. Correct? CAG shall appoint. Simple. We have written this also. Within 180 days of financial year. Subsequent auditors. X purchased the car from Y believing that Y was a legitimate owner. Although X paid the full purchase price and took the possession of the car, he did not check the registration certificate. He did not check the registration certificate of the car to verify the authenticity of Y's ownership. Later, it was discovered that Y was not the rightful owner and the car had been stolen. In the context of good faith, General Clauses Act, what is good faith? Basically, you should have done your thorough research. You shouldn't have acted negligently. Then why did you not check the RC? Simple knowledge, one document can't you check? So determine the validity of X ownership. Obviously, he doesn't get the good title. Holds valid ownership, Allah. Does not hold valid ownership. His purchase was made without due care and attention, even though he acted honestly. Correct. Because without due care, negligence. B is the answer. Okay. Done now. That's all MCQ. Simple ones, I believe. Okay, next one. XYZ Limited issued a prospectus to raise funds for new manufacturing project. After successfully raising the funds, the company identified an investment opportunity in different industries 6 months later, requiring a significant portion of the funds. The proposed investment involved trading in equity shares of the other listed companies. Most of them would have taken it wrong. Okay, the board of directors suggested varying the original objects for which the funds were raised to allow this new investment and recommend passing a special resolution in company's general meeting. While the promoters and controlling shareholders supported this change, some shareholders expressed concerns, particularly regarding the deviation from the initially stated purpose of the funds. Based on the provisions, advice on the validity of the proposal to redirect the funds towards this new investment. 90% of them might answer this wrong. Why? Remember, if you guys refer to section 27, there are some things you need to remember. What is that? Whenever a company issues a prospectus and if they raise money, if they have to subsequently alter the object clause, you need to keep certain things in mind. What is that? First one, you need to make sure you need to amend your MOA, that is object clause, and prospectus also, because you have told this and raised money. For that, you need to pass a special resolution. Second thing is, people, that whenever there is anyone who is not agreeing with your the special resolution should be by postal ballot. Whoever is not okay with it, you should be giving them an exit opportunity. Dissenting shareholders, you should be able to buy back their shares and give them an exit opportunity. Tell them to leave. The fourth thing is very important, people. Whatever is this object change, meaning you have taken money prospectus for doing a particular business. Now you want to use that money into some other business. Remember, this some other business can be anything in the world, except the proposed investment should not be for buying the equity shares of other listed companies. It cannot be this. It can be anything else, because this is the only exact words that are prohibited in section 27. So if at all a company wants to change its objects and they want to do this alone is prohibited. Even if you pass special resolution, section itself says you cannot use it for that purpose. So So all of us will be writing this answer from exit opportunity point of view. The one you guys have to focus is this, that even though you take any approval, you guys cannot do that object. Not allowed, not possible, because it is prohibited in section 27. Understood away? Pakana. Okay, tricky. Okay. XYZ Tech Solutions Limited is a growing technology company that has seen significant contribution from its employees and directors in the development of a groundbreaking software product. To reward these key contributors, the issues sweat equity shares. The company has paid up equity share capital of 20 crore. The company has proposed to issue sweat equity shares worth of 4 crore. The company's board has drafted a special resolution outlining the proposed issuance of sweat equity shares, including specific details and the class of director and decision. The company has approached you to advise them about the issue of the sweat equity in line with the provisions of Companies Act. What and all I need to do? First thing, I need to pass a special resolution. Whenever I pass a special resolution, it will be valid for a maximum period of 12 months. Within that, I have to make an allotment. Next one, I need to clearly tell that with whom and all I am giving my shares. Explanatory statement, clearly explaining the names, directors, what price, purchase considered, everything I have to intimate in the explanatory statement. And the maximum I can give is how much? At once, I cannot give more than 15% of the paid up equity capital or issue value of 5 crore, whichever is higher. That's the provision now. Now, in our case, what is the capital? Our capital is 20 crore. That's what is the capital. 1 second. What is the capital? 20 crore. How much is your capital? 20 crore. So 20 crore into 15%. How much is it? 15%. That comes to 3 crore. Yes, or 5 crore. 3 crore or 5 crore, whichever is higher. How much is it? 5 crore. I can give up to 5 crore. But there is one more requirement also. At any given point of time, in the lifetime of the company, if they have already given sweat equity, everything put together cannot exceed 25% of your paid up equity capital. Now my 20 crore is there. 25% of it is 4 crore. So what is the maximum I can issue? So even though whichever is higher is 5 crore, but because of this 25% is 4 crore, the company wants to issue 4 crore, correct? Somewhere they have given no. 4 crore. Possible? The answer is yes, possible. So you need to show all these calculations, then you will get a mark. I hope it is simple. If with a startup, this 25% can be up to 50%. Remember that also. If they somewhere drop a Hiroshima Nagasaki bomb, you should be able to counter it. Okay. PQR Limited, a manufacturing company, is in the process of expanding its operation. To support this expansion, PQR Limited has acquired a plot of land along with buildings on it from ABC Limited, another company in the same industry. The property, however, is subject to an existing charge. So ABC have created a charge on that property. PQR Limited is purchasing it. This charge had been registered by ABC Limited at that time. The directors of PQR Limited are of the opinion that as charge for the property was already created, there is no further obligation to be fulfilled from the side of PQR Limited. After negotiations, the bank accepted. Advised whether the contention of directors of PQR Limited is correct. What is the contention? They are of the opinion that because the charge is already registered, you need not further tell it. No, people, the contention is wrong. Whenever a property subject to a charge is purchased by some other party, in our case it is PQR, it is the responsibility of the buyer to intimate to the ROC about such modification. This will amount to modification of a charge. You need to file Form CHG fund. So in the books of ROC, ABC Limited charge will be considered as accomplished, satisfied. Now the fresh charge will be in the name of PQR. So whatever is the opinion given by the PQR Limited is not valid, and hence it is incorrect. Section 79. Okay. Vishal Limited is an unlisted public company having 5 directors in its board, which includes 2 independent directors. SAM Private Limited is subsidiary company of Vishal Limited. So there is Vishal and there is subsidiary SAM. Actively carrying on its business, having paid up capital of 1.5 crore with 40 members and turnover of 18 crore. And the said company is not a startup. It's not a startup. It is also provided that SAM Private Limited is not a startup. Okay. In the context of aforesaid, please answer the following. Whether SAM Limited is mandatorily required to prepare cash flow statement for the financial year as part of its financial statements and provide your answer by analyzing limit into the category of analyzing SAM Private Limited into following categories of companies. The first question I'm asking you people, should they prepare a cash flow statement? If you guys remember the cash flow statement, it is exempted for a few companies. If you remember, the cash flow statement is for sure exempted for OPC. It is exempted for a small company. It is exempted for a dormant company. It is exempted for a private company which is a startup. So for all these companies, the cash flow statement is not required. Now what they are telling you, whether SAM Limited is mandatorily required to prepare cash flow statement for the financial year as a part of the financial statements. Are they required? The first one, are you OPC? First of all, are you a small company? The answer is, are you a small? Obviously no. I can tell you why. The small company definition, if you remember people, section 2 clause 85 says that a holding company, a subsidiary company can never be considered as a small company. It is a subsidiary company. Next one, a public company can never be considered as a small company, because what is a small company? A company other than public company. If you are a subsidiary of a public company, you will be deemed to be a public company. Even on those grounds also you cannot be a small company. Because you are not a small company, yes, you need to prepare CFS. You don't have a choice. Yes or no? Okay, next one. Dormant company respectively. Okay, so if at all it's a small company and if it's a dormant company, are they exempted from giving CFS? The answer is yes, they are exempted. So if a SAM Private Limited, if it's a dormant company, are they exempted? Yes, they are exempted. They need not prepare CFS. But people, there is one catch here, people. If at all you are actively carrying on your business, you can never be a dormant company. You can either write it with an assumption, assuming that as per the question, if at all the company is obtaining a dormant status, then yes, they need not prepare a CFS. But as per the given question, SAM Private Limited can never be a dormant company because they are actively involved in the business. You can write your answer with this assumption. That is when it will hold that grip. Yeah, because I believe that they are telling you analyzing. Analyzing means this is analysis only, no? Instead of just writing off directly dormant can be, you can analyze and write it this way. So remember, Brand Limited is an unlisted company having its registered office at Agartala. The company scheduled its AGM on 31st July 2024 in Goa. The meeting commenced at 3 p.m. and concluded at 6. It is also provided at 1st July 2024. The company had obtained written consent from all members via email agreeing to hold the AGM at out of state. Evaluate answer. Remember people, if you are a listed company, you need to conduct your AGM in your registered office or within the city or town or village. You cannot go beyond your city, town, village. But if you are an unlisted public company, you can go anywhere people within India, provided all your members agree to it in writing. In this case, yes, it's an unlisted company people. So you can conduct it anywhere in India. Possible, allowed. So is this valid? Yes. Provided a meeting should be conducted between 9 to 6. 3 p.m. to 6. Is it valid? Yes, it is valid. Simple, huh? Yes. That's all, huh? HD is engaged a business providing software service. The company appointed its statutory auditors, not the first auditors. The board of directors of the company informed the auditor that the fee shall be fixed by the board only. But the auditor objected to the same. Now the directors have approached you, advise them. Remember people, if you are a statutory auditor, the remuneration and your appointment, everything should be done in AGM. So who will approve it? It will be approved by the shareholders. See, they are telling you specifically, not the first auditor. If you are the first auditor, only the first auditors appointed within 30 days of incorporation, their remuneration and appointment will be done by the board. But if it is a statutory auditor, that is subsequent, after first, the remuneration and appointment has to happen in AGM only. So in this case, people, whatever is advice given by the company is wrong. Whatever is advice given by the auditor is correct. Simple. Next one, last three questions. Amit and Priya are partners in XYZ LLP, a consulting firm. Recently, Priya moved to a new address but forgot to notify the LLP within the required period. A month later, Amit's cousin Ramesh expressed interest in joining XYZ LLP as a partner. And after a few discussions, he was accepted as a new partner. However, XYZ LLP did not immediately update the register of companies regarding Priya's address change or Ramesh's admission as a partner. 2 months after Ramesh joined the LLP, filed a notice with ROC about these changes. Advise LLP about the default and part of LLP about the non-compliance. Yes, there is a default, people. Whenever the partner's details change, the partner has to intimate the LLP within 15 days. LLP has to intimate it to ROC within 30 days. And whenever a partner is appointed, the LLP has to intimate the ROC within 30 days. So have they done a non-compliance? Yes, because they have done it after 60 days. Is it a non-compliance? The answer is yes. Simple? Done. The Parliament recently passed Environment Protection Amendment Act 2024 to strengthen the regulation and industrial waste disposal. The Act specified the commencement date as 1st December 2024. The President gave assent to the Act on 15 July 2024. Simple, people, General Clause Act. What does General Clause Act say? Whenever there is a date specified in the Act, then the law will be official from the date of the date specified in the Act. Here they have clearly given that the date specified is 1st September. It will be 1st. What if this is not mentioned? If this is not mentioned, then it will be the date of President agreeing to sign. In this case, it will be 1st September 2024. Next one, at the time of interpreting a statute, what will be the effect of usage or customs and practice? Simple, people, interpretation of statutes, 2 things they are expecting you to write. One is with regards to optima legum interpres, yes, constitute, nothing but the custom is the best interpreter of law. And next one, people, contemponia exposito non est optima et forcitinia in league. If you guys remember, sorry, the answer, something, but you remember those 2, no? That's all. That is what they are asking you. Effect of usage or customs and practice. Clear? Optima legum and contemponia exposito. What is contemponia exposito? Basically, the contemporary authority is the best interpreter of law. Whoever was the regulator at that time, he is the best authority to interpret. So go back and read the regulations or circulations what he had given when he was the regulator, statutory authority. You need to consider those words, not today's words. Ravi, an Indian citizen, works as a software engineer for an international company. During the previous financial year, Ravi resided in India for 200 days. Previous year resided 200 days. So 180 days condition satisfied. However, in April of the current financial year, he accepted a job offer in Canada and left India with a long-term work visa. Simple, no, people, in the previous year you have satisfied. In the current year, if you are going out for those 3 purposes, and the first one is what, people? Your employment. If you are going out for employment, even though you have satisfied 182 days condition, you will not be considered as a PRA in the current year. He is going in April only, so he will not be considered as PRA. That's all. A quick takatak, good question discussion. I hope you guys were able to make a good number of points of provision. Do let me know what and all provisions you guys were able to get it right. I want you to be very, very what? Honest? And do tell me if there is a point where you went wrong and why did you think you went wrong. I want you to tell me in the comments. And do let me know what is the next video you want to see. I'll try my best to come and discuss that with you guys. Thank you so much. See you in the next video. Bye bye.